Sage, we represent a bunch of municipalities, but one of the things we also do, and I do some roadshow programs for land use commissions on the Land Use Academy's faculty, but also for the Connecticut Council of Municipalities. Partner of mine, Duncan Forsyth, who actually came out, he and I were supposed to come out a couple of years ago. I think it was a couple of years ago to do that, and at the last minute I had to go to another evening meeting, so we came out and did, I think, a presentation at the library. But we do these, so I'll jump over this is just about me, and jump into the more important part. Probably the only part about me you need to know is I practice out of the Hartford office of Howard and Sage, and the municipal group and land use and environmental group do some other general practice work, but the majority of my work relates to municipalities and matters involving land and both from the environmental side and land use approvals and litigation. A lot of it is when towns are sued. We're talking to the FOI, go do hearings in the Freedom of Information Commission, and then if they can go from there to the Superior Court, handle those. Land use commissions go to the Superior Court, handle those, and then up to the appellate court and the Supreme Court. But what we try to do is keep people out of court and keep business, help advise towns that ways in which they can move business and solve issues, because it's amazing how complicated municipal law can be. But the one thing that is a constant for all the participants in municipal law is Freedom of Information Act. We're going to cover some parliamentary procedure. I'll spoiler alert and tell you that the parliamentary procedure, especially when you're dealing with municipal commissions, are not big bodies. They're smaller groups, and there's flexibility in the way that you do parliamentary procedure with smaller groups. We're going to go over Robert's Rules. Robert's Rules was really, a lot of it was designed for larger bodies. And so some of the most formal parts of it, you don't necessarily have to follow to the T when you have an 8-person, 9-person, 5-person commission. It's a guideline, a guidance document, and a lot of it is common sense tests. But if you understand it, as much as you can understand about it strictly and how it works, it will help you deal with moving business, because having agendas, having people keep to agendas, being able to control the discussion to things that are actually in business before the commission is all what Robert's Rules is about, so that you can have an informed decision-making process. The public can understand what you're doing, and you can do it in a way that most commissions get along. And one of the ways they get along, even though they're from different parties, different views, is partly by having a good procedure and good chairman to help make the process be as smooth as possible. Now, the first part of what we'll go through is actual freedom of information provisions and what constitutes a meeting. And it's most everything. There's some exceptions we'll talk about, but whenever there's a quorum of a multi-member agency, that is going to be a meeting, whether it be a hearing or whether it be just a regular meeting. That constitutes a meeting. So a public hearing is a meeting for the purposes of FOI. Now, in the modern world now, you see not on this slide, electronic communications, if included, you can have a meeting if multiple people. In fact, if you go to the Freedom of Information Commission, quite often there's members of the commission that participate in those meetings by a phone, with a phone, teleconference style phone on the table. And as long as members of the public, or in that case it's a meeting room not much larger than this one, if the people who are entitled to hear the proceedings can hear what that commissioner is saying through the telephone, and conversely that commissioner can hear questions that are raised by the people at the table who have the opportunity to present information, then it's appropriate. But one thing that's not on here that you've got to be careful of is emails. If you are communicating among your members, there are certain exceptions, like communicating an agenda, communicating what a meeting is going to be. Things of that nature are not substantive discussions. But if you're communicating, you've got an email chain and say this thing has come, this application has come before us, and people start chiming in a little bit about, oh boy, I'm concerned about this or that or the other thing, that's a substantive discussion, that would constitute a meeting, that would have required the typical process of a special meeting notice and the rest, so.
Only if there's a quorum, Ken?
If it's a quorum, yes.
I mean,
But
two
the-
people could do it.
Right, the problem with an email chain though, if two people communicate and then that goes to the next person and that goes to the next
Oh,
person,
yeah.
it gets a little tricky with email.
Of course.
But if you're if you're two members or less than a quorum, are talking a little bit of business, I mean, normally you wanna do as much as you can in the context of the public meetings, but if you have less than a quorum and you're talking, it's not a meeting, and you don't have to worry about it. And even if it is a quorum, and I'll get to it in a couple seconds, there's some exceptions of even when you can be a quorum, and it not constitute a meeting that requires that.
Question?
Yes.
If a document or a public hearing was coming up before the public hearing, and some information was given and it was disseminated out to the members by email, is that considered a meeting?
No,
Okay.
what's a meeting is when people are communicating, deliberating, they're a body, no individual can make a decision themselves. So when there's a quorum, they're now the body, they could be doing business and transacting business. If a staffer is sending information around, okay, this is information that an applicant has submitted, we'd like you to have it in advance to be able to review it before the meeting. That's good business. You'd like an opportunity to review them so that you can ask questions of people in advance. So if somebody sends that around, if then that goes around and then somebody decides to reply to all and say, I don't think that application is complete because it should have had an A2 survey with it, and somebody brings back and says, no, that's not required, that's a meeting. Right, so just sending the information out and things like agenda, not an issue. But when you're starting anything substantive, and when I say substantive, it could even be a procedural issue where someone says, boy, I don't think that we should, I don't like the way that we see alternates, or I don't like the way that the room is set up. I mean, those are all discussions that should be had in the context of a public meeting if a quorum is involved with it. So the real exceptions would be sending, letting agendas out, getting information out in that way. So there are certain things by statute that are specifically designed to not be a meeting. And you can have a personnel search committee for an executive level employee. That can happen, and you can have a group of people who do that process. It's not a meeting. If you happen to be all together at a social event and you have a quorum of one of your members, that's not a meeting. Collective bargaining agreements or negotiations, not a meeting. You can caucus among members of a single party, and a group of you can get together, and even if you're in the majority on a particular commission and you decide to caucus on something, then that's not considered a meeting. If you're a single member agency, you meet with staff, not a meeting. Again, I touched on it before, if you have communications regarding notices of meetings or agendas, that everybody can be involved in that and not constitute a meeting. And then if you happen to go to, the entire Planning and Zoning Commission decides to go to a wetlands meeting because they want to hear something, the fact that the quorum of the Planning and Zoning Commission happens to be a wetlands commission doesn't make it an official meeting of the Planning and Zoning Commission.
Oh, we
Now,
were
they can
told
do
the
joint
opposite.
meetings. Joint meetings are another story altogether. If you have business where you want to have an opportunity to do business and to hear information, ask questions, participate, a joint meeting happens, they both should be noticed, that should happen. But if for whatever reason, you might not even do it, on purpose, you all show up and it happens to be members of the Board of Finance happen to all be at a Planning and Zoning Commission meeting that they happen to have interest, don't even know they're all gonna show up there, and it's a quorum, that's not a meeting. But if they want to conduct business at the same time, then you would treat it as a joint meeting and they both be noticed. Now this is executive session. When can people be excluded from the room? Because the whole purpose of the FOI is open government. Everyone should be able to see what their government's doing, and even if they can't participate in the meeting, they have an opportunity to see what's going on. The exceptions are you can go into executive session to deal with personnel issues, that if you have a staffer of the particular commission and you need to discuss among yourselves concerns about personnel, that can be done. If there's pending claims in litigation, and that can even include if you're considering, an agency was considering whether to take an appeal or take action, it's not always defensive. If you're considering bringing a claim, that constitutes a claim for the purposes of executive session. Purchase of the sale of land, which makes sense. You don't want to be able, you're going to make an offer on land, you want to potentially negotiate or consider it, you should be able to talk about that outside of the public eye. And this one is built in for public security. A lot of commissions, won't have something like that come up, but if there is a public safety, public security issue that needs to be discussed outside of the view of the public, that can happen in executive session. And here's some others, site selection, and the instances in which documents are going to be exchanged which should otherwise be protected from disclosure. A classic one is a letter from a lawyer where you get legal advice. So if there's a legal opinion, it's a confidential one, and that's going to be put out on the table, and maybe there's no pending claim. Maybe it doesn't qualify as a litigation-style claim issue, but there's advice that's not the kind of advice. And when you're a municipality, you get advice that, an opinion of the town attorney that just gets put right on the table and everybody knows what the town attorney says. But every now and then, there's advice that you want to, that's what attorneys can do for. You want to be able to have a confidential exchange of advice. If that's something that the town attorney is going to be reviewing, you could go into executive session for the purposes of doing that. There's other kinds of privilege. The statute lists a couple things where things are privileged and you wouldn't want that out and disseminated. You can do an executive session to discuss it. One thing I'll just point out on there, to jump through this slide, is if you're going to have other persons attend, you should indicate that in the minutes. So you can have an executive session where someone is invited in. A classic instance might be where, say there's land use litigation and there's an effort to try to settle the litigation, and the commission wants to discuss, and the two attorneys want to have an opportunity to discuss possible settlement of the litigation. It's a pending claim. The minutes would say that if the applicant who's filed the lawsuit, who is going to be invited in with his attorney to discuss potential settlement of the litigation, the minutes need to say that that person was invited into executive session. I have seen meetings where they have to be open to the public. That's obvious. The next one is the public can't be required to sign or furnish information as a condition of attending. I have been at public organizations, public agencies, that is their practice. They have a sign-in sheet and they'd like people to do that. But if somebody walks in and says, I'm not going to tell you who I am, I'm going to sit right there in the chair, they absolutely have a right to do that. They can also be photographed, recorded. Somebody can't disturb the normal functioning of the meeting. You can't come in and walk around with your giant camera and be zooming in on people when they're doing business. That can be prohibited. But somebody wants to sit down with a little tape recorder and put that on the table and start the recorder, they absolutely have a right to do that under freedom of information.
Ken, a quick question. If you have a town meeting, registrars can check off if you're a voter of the town. That wouldn't be...
No, that would not violate that problem. It's a matter, it's being in attendance of a governmental meeting, and you want to be able to observe it. You can't be required to identify who you are and to sign anything there. But if you're going to be determined whether or not you're an elector or legal to be able to cast a vote, that's perfectly appropriate.
Ken, question, during our public hearings, when we open it up to public, we ask them to preface their comments with their name and address. Is that correct? Or incorrect?
Absolutely. That's a different story. That's a matter. That's not an FOI matter as much as it's the way you conduct your public hearing, in which there's going to be evidence. If there ever was an appeal, there's a record of what happened in front of the agency, and and I'm guilty of failing to do that. But every time you get up, you should say, for the record, Ken Slater, and then start speaking, so that when they have to take a transcript of what people say, they'll know who it is. So no, that's absolutely permissible and recommended that that happen. And within 48 hours, the votes of members need to be put down. The minutes of the meeting, frankly, they've done. If there's a formal vote, it's supposed to be within 48 hours. And minutes should be made available for public inspection within 7 days, is what the FOI provides for. Now, at the beginning of the year, you establish your regular meeting schedule for the entire year. first meeting should be 30 days after that's filed, and then agendas of regular meetings should be filed at least 24 hours before the start in the regular office of that agency, if they have one, and if not, at the town clerk's office. And also, they've included a requirement that it should be on the webpage if you have one available. Not every town, believe it or not every town has one. Most do. If you do, then, you know, and I think most towns try to utilize that, because more and more that's, you know, I can't tell you how often, I'm sure you do the same thing. I'm gonna go to a meeting and, you know, I used to be calling town clerks or calling the local, local zoning enforcement officer or whatever, and just being able to go on the webpage and pull up the agenda for the night is very valuable. If something is not on the regular meeting, it can be added with a vote of 2/3 of the members present and voting. It's not on the agenda of a regular meeting. A special meeting is another story. Now, a special meeting is going to be called. It has to be posted at least 24 hours before, and the notice has to state the time and place of the meeting, because of course the other, a member of the public can know when all the regular meetings are for the entire year, because that's been published before. It's going to be a special meeting. All of the details of where it's going to be, and the business that's going to be transacted. And the only business that should be transacted is that which is on the special meeting notice. Even if you have a vote of 2/3 members, you shouldn't put a new matter on a special meeting. Now, there's a requirement, and I think this is often not followed, because most of the time you're going to have all of the members, you might have all the members of the commission. You decide, okay, let's have a special meeting too. And even presentations like this, I've had, we do this for land use commissions, and they decide they're going to have a special meeting because they know they're going to have a quorum of their members, and they don't send a notice to all of the members of the commission at home. But under the FOI, that's required. But if the person shows up, then the fact that they might not have gotten notice at home is waived. So
How do they define notice at home? Is an email an acceptable notice at home?
I believe it is, actually. I don't know for certain. I bet you in the old cases it had to be a mailed writing, but more and more the FOI is getting with the times and some of that. If you have I'm only guessing, I don't know this for certain, but I bet you if there's an established mechanism among the commission that this is how you communicate with me, and that's been emailed, I would bet that's in compliance. But you want to be conservative than the old-fashioned snail mail delivery or hand delivery to the home. All right, so those are the basic parameters of FOI. Before I go on to effective running of meetings and then parliamentary procedure, any issues of FOI that, it's been great that you ask questions that I go through, and I ask you to do that, but just in case there were issues of FOI you're expecting I was going to touch on that I haven't, now's the time.
Okay, I think back what I said about lawyers, that was only a joke.
Oh, of course, I welcome good lawyer jokes on the record.
Okay, we've had a couple of situations locally, specific situations, that I would like to question. One I know the answer to, I think, but I just want to be sure. 2 of the last 3 selectmen suspended public comments sections for meetings.
Mm-hmm.
They were in agendas, half the year, and then all of a sudden they decided they were gonna omit that. I believe that's legal under FOI. It is, and they can do that.
Well, the analogy I use to a regular meeting of the commission is more like Congress, in that you can't walk in. Again, the culture of every town and every commission can be a little bit different. And I've been asked the question, well, do we have to have an audience of citizens or a public comment session at our meetings? And the answer to that is no, you don't. People can watch you transact your business, and you have the ability to participate in public hearings if there's a public hearing. But if it's a regular meeting, really FOI only lets you sit and watch what they're doing. Now, a lot of commissions will want to, I find boards of selectmen will often want to have that opportunity to have people come in and voice their concerns on an audience of citizens. So it's certainly not required, but it's permissible. But your question might be one level deeper than I just touched on. Is your question of whether or not the chairman can unilaterally take something off the agenda, or is the question whether or not they need to have a public audience type of a
Yeah, I
issue
wondered if
on
the
it?
chair can do it without getting a majority, the approval of the majority of the committee if it violates pre-existing, conditions.
The chairman sets agenda, but what can happen is the agenda, if the majority of the body, I believe it's 2/3 would be required to override that and put something on the agenda that's not already on there. And you could go through the exercise of every meeting, it's a regular meeting, you can add it. 2/3 of the members who thinks it's a good idea to do it, you move to amend it and put it on there, and then presumably the chairman's gonna get the picture that, let's just put it on there rather than go through that exercise. But other than that, the chairman does establish the agenda for the meeting, subject to the rights of the others to add things that aren't on it.
And the second point is much more important. This was a cause of quite a bit of conflict in our community. The previous first selectman issued a letter, a page and a half, in which it's hard to summarize because he makes a number of arguments, but he basically argued that if you're on a board or commission, the only person who's legally authorized to state the town's position regarding an issue is the first selectman, which may be true, but he goes on to talk about the fact that, we should really be careful what we say to people in public meetings, that if we're invited to public gatherings of citizens who have a particular, let's see what he says here, special interest, that they're pressing up against the town, that committee chairs and members, he says here at one point, outside of the voting booth, we give up our right to participate. I was brought up on, Jefferson. I taught a college course on Jefferson for 30 years, and it seemed to me it was anti-democratic and so loosely worded that it couldn't be enforced. For example, if I'm in a grocery store and somebody comes up and says, "You're on the Water Pollution Control Authority," and I say yes, and he asks some kind of a general question, I'm not projecting that I'm, speaking for the board or official policy, but I might be able to say, yes, they're worried about this, or they're gonna put the sewer in there. And this seemed to indicate that you couldn't do that, that unless, we went through the whole formal procedure for establishing a meeting with agendas being distributed and so forth, you couldn't make normal comments. Just two quotes from it. With all of this being said, we cannot lose focus of our duties to the entire community and should not be swayed by or involved with special interests. Special interests encompass many forms, no matter how positive the cause may sound or be. Groups working outside the governing body of a community to influence the outcome of future decisions by elected and appointed officials appear to be special interests with an underlying agenda. Now, if you focus on that, the Little League comes in and they want, the bases to be put in before the game, and somebody else comes in and they want the Cub Scouts to be able to have a car wash in the parking lot and things like that. They're all, in a sense, special interests. It seems to me that just because you're appointed to a board or commission, nobody can tell you you don't have the right to talk to these people or to comment generally on it. But here, and it was just two things that really, I thought, carried this too far. Turned the whole intent of the Freedom of Information Act on its head, really. One point he mentions here, while we are all citizens and taxpayers, outside the voting booth, we inherently lose our right to act as individuals and private citizens when it comes to matters that affect the community and are governed by law. That's pretty sweeping.
Yes.
Practically everything you deal with every day, whether it's a stoplight, if you want a sign here and so forth, all of these things involve that. And it is important to explain to people we cannot unilaterally act on a request and make a decision without a consensus of the board or commission. Well, that goes without saying.
Sure.
But you're simply stating your opinion as an individual. My question would be this: if since I'm on now 2 commissions, have I given up my right to meet with somebody in a grocery store or talk to the Little League or something else about the concerns they have?
All right, we cover a little ground in there, and let me, I'll start in the biggest picture. And, in the general sense, no, you haven't. You certainly haven't given up, certainly in that kind of an example where someone from the Little League is talking to you, or you're a member of WPCA and somebody comes and asks a question, and, what is there I'm thinking of buying a property, do I have to pay a special assessment if it's already, the sewer system's already in? And you have a conversation with somebody about that, perfectly appropriate. You can voice your opinions before other boards, but the common sense test has got to apply, because sometimes your role is not just as a member of a commission that's, you know, operating business. Like, well, let's talk about, you know, first selectmen, the board of selectmen. They're establishing the biggest policies of the town. And they sure should be listening to voters when they're out walking in there, you know, it's gonna be a pain in the ass, there's two men in the room, no, one really learning quickly and one had a fair amount of experience with. But, you know, every time you go to the big Y, somebody's gonna try to grab your ear and talk to you about something. You can't not talk to them. I mean, that's part of what you're responsible to do. Now, let's drill down. Now, let's go on the other side and say that you're going to be an arbiter of a potential dispute. You're a member of a wetlands commission, and there's a public hearing on a wetland permit, and it's hotly contested. There's a lot of opposition to it, and you're going to be put in one of these chairs to hear all of the evidence and make an unbiased decision. So a member of the public sitting where you are don't believe that I am, you know, have a bias one way or the other. Let's say it's the Little League field, and they want to do something at Keeley Field, and you know, there's a wetland issue, and you've served on the board. It was your idea that they, you know, make this expansion and put another field in that's going to require a little bit of filling the wetlands. Obviously, in that circumstance, you shouldn't sit on the commission and make a decision. So when there's a continuum of when the situation is that you could be out there saying things and voicing your opinions that could be harmful, if you're going to have something that's in front of you relating to that matter. Most of the time, that's not going to be an issue. If somebody comes up to the Planning and Zoning Commission and say, you know, I'm thinking of putting, you know, some kind of a store on the west end of town. What do I do? You know, and you're a member of the commission. You say, you know, there's a form. You go downtown, grab the form. You got to look at the regulations. Maybe that's a special permit that you're going to have to apply for. Maybe not. You have that kind of dialogue. It's fine. You're meeting with a group of people who are going to be applicants, and you're meeting with them in the parking lot, and the public sees you. I mean, obviously, you walk out of the meeting and people are cordial. It's a small town. That's the way things should be. But if before every meeting you have a little caucus of all of the applicant, and you're sitting around in a circle nodding for 15, 20 minutes before the hearing, will walk in, and then all your comments suggest that you're biased in a particular way. That's a bad idea. So you just got to use that letter is overreaching for sure. And there are plenty of things using the common sense test that just because you're a member of the commission, you're the people that get things done in town. You should be the ones that should be able to talk to the different organizations in town and what they might be able to do. So, but just in the instance in which you might be dealing with something that could lead to litigation, in which you are supposed to be perceived to be an independent mind, do your best. Not would be an instance where if I know there's a matter that's coming before me and I'm on the Wetlands Commission or the Planning and Zoning Commission, and there's going to be a public hearing and somebody tries to grab my ear and say, you know, this is a terrible idea. That's one of those ones that say, I'm sorry, I mean, I'm a member, I'm going to decide this. Please come to the public hearing. We'd love to hear you. You have a right to come to the public hearing. This is an important application. We understand that, but I can't talk to you about that. So there really is a differing standards of instances in which you can be expressing your opinion. And there's case law that says that everybody has opinions. You can't possibly come and sit on any commission and not come to the table with opinions. You just have to show that you have an open mind and you're going to listen to what people have to say. One thing, you know, we teach, you know, I'm using some wetlands references, but there's one right way and a wrong way to say something. And you said something about, you know, the Willimantic River watershed is extraordinarily important. And you're really going to have to convince me if you want to do a major project within that. All ears, but understand it's very important to me. You say that on the one hand, you've not suggested that you've made up your mind, you're going to hear the evidence, you're going to listen. And on the other hand, you said, you know, there's no way I'm going to allow anything in the Willimantic watershed. I'm not making it up. People have done stuff like that. Big mistake. So you know, just that letter is certainly overreaching, and I don't agree with a lot of it. And there are some instances in which you should use that discretion when you're a judge, as opposed to someone who's just a working member of the commission who should be communicating with the community. So, did I cover you?
Oh, it helps a lot, tremendously.
All right, one of the most important parts, what I said at the beginning of this thing, is the responsibilities of smooth running of a commission, an agency, is the chair. And, you know, it's amazing how different the dynamics from commission to commission, from town to town can be. And human dynamics change with every election, and that's, you know, part of what a chairman is supposed to try to do. And by following, having a protocol that people expect and understand. For example, the audience of citizens issue. I mean, in towns that don't have them, we recommend to the chairman to announce to the public, if you're sitting there, this is a meeting of, you know, say the Planning and Zoning Commission. This is a regular meeting, not a hearing. You are obviously entitled to sit here and listen to what we do, but there's no public participation in our meetings, so you should understand that. And there's that, you know, that is something that becomes part of the culture of that particular commission. People understand it. If it's on the agenda, fine. If it's a public hearing, they can comment. On the other hand, if you have an audience as citizens, commonly you make it clear you're allowed to speak, but not on things that are on the agenda. And you know, that's a lot of commissions, more land use commissions. But if it's on the agenda, we don't want to hear about it in an audience of citizens. If you have something else that you want to tell us about, then tell us about it. That's less the case, again, with like boards of selectmen or councils, when they are often more liberal in wanting to hear concerns that the public might have than, say, a land use commission that's trying to work an agenda of a bunch of items and don't want to be, don't have as broad policy considerations to listen to as many people. So some of the, you know, ideas is to begin and start on time. You know, we started this meeting about 7 minutes after, you know, it was supposed to start, because it made sense. And people from different commissions, people were going to come in, so you use common sense. But to the extent that you can have things, people expect you're going to start on time or very close to on time, that's going to help set a tone. You know, be organized, have your agenda. We'll talk more about how you follow agendas and how you keep to them and how you can change them. But that's a very important tool to govern how things are going to go. A lot of, I say in that third one, be prepared, have bylaws, standing rules, Robert rules, list of committee members. I don't know many small, you know, town commissions that are sitting with a book of Robert's Rules of Order and are having to order, not, you know, somebody making a motion of, you know, dividing the committee and having, you know, standing votes. That doesn't happen in smaller groups. So this is part of the CCM training, but if you do have bylaws that specifically say how you operate your procedure, how you seat alternates, things of that sort, you need to be familiar with those. The kinds of rules, and you should be familiar with Robert's rules. And I'm not saying you shouldn't, but you know, having to stop at every meeting and try to look up page, you know, 302 of what order we ought to consider motions is counterproductive. But the more you understand the more about them, the more you can be able to control when you have somebody at the end of the table who's trying to take over your meeting. If you understand the rules, you should be able to move that and be in control. You're going to have to keep people on agenda sometimes. Sometimes you get people that are, you know, right on the money. You don't have that, but there are commissions, and we probably all served on one or two, where you have someone who's got, you know, their pet issue, and they want to bring it up every meeting, whether it's on the agenda or not. It's the chairman's job to keep everything in order in the way that the agenda. Again, small town commissions, and you know, there are instances in which you certainly don't need to do that when something comes up. But in the event that in order to move business, you've got, you know, the best way to deal with the disparate point of views on the table is to be firm on the agenda, then that's what you should do. And it's just a matter of judgment and as your commission develops. Yes?
A question on that last slide.
Mm-hmm.
You mentioned quorum, and you mentioned going to recess or adjourn. On zoning, maybe incorrectly, we've had a situation where the chairman was there with one other person. We did not have a quorum. The chairman opened the meeting. We were told she could do that actually alone and seat alternates to get a quorum and then have a meeting. Is that the case or not?
I believe it is. If you have, because the alternates are standing in the shoes of the regular members. So if you have enough people there that are members of the commission, albeit all alternates, I believe that is correct. That they-
Even though there was no quorum, the chairman sitting alone up there,
Yeah.
they can start the meeting.
You know, I have to admit, I have not seen a case on this specific point. I'll look into it and I'll report back if I find something on it. It strikes me that the absence of regular members, I mean, the purpose of alternates are to sit in the shoes of regular members.
Right.
And you know, when you're four of you sitting at the table and you need a quorum of you know, 4 people, and it happens that 3 of them are alternates, you know they're all gonna be seated. So so I think you should be able to call that meeting to order. I don't know for sure though, that's my instinct.
Okay.
And I'll look into it.
No, I have another question about
Yes.
alternates. If a regular commission member knows in advance of his absence for a meeting and requests from the chair that a certain alternate sits for them, does the chair have to honor that request? Or does the chair just seat the alternates of their choosing?
It depends. There are some instances where statute, and I can't tell you exactly what it is, but there are some in which a person who's not seated can designate a member of the commission who's going to sit in their place. I don't think there is one related to planning and zoning. I think whatever the ordinary protocol is that the commission has for seating members would govern, so that the person, you know, you could have courtesy and decide that that's the way you like to do it, and the commission likes to do it. But if someone wants to be, wants to stick to the rules can be established, and someone might express, I'd like to have Mrs. Smith sit in my place, but if that's not the ordinary rotation that you sit people, or the ordinary mechanism in which you sit people, you don't have to honor it.
So you put that in a bylaw?
Unless there's a statute or a bylaw, that's right.
Mhm.
you could do that.
Thank you.
All right, still with the chairman, chairman does have the ability to participate in debate. The recommendation is use that very sparingly. I mean, your real job, hopefully you have good commissioners who understand the issues and have a good debate or good discussion, and you don't need to really guide that. You have a right to, and you should participate when it's appropriate, but you shouldn't control the meeting. You should guide it and let the commissioners participate. One of the things, when we talk a little bit about parliamentary procedure in a little while, one of the steps is for a chairman to state a motion that's going to be acted upon. State it clearly, state it precisely, so that people in the room know what's being voted on. That's very important. Some commissions are just, somebody makes a motion, somebody says second, all in favor. The appropriate way would be for the chairman to state, the motion has been made to X, and then call for the vote. And then the chairman should do that. Again, it's not a hard and fast rule, it's not a statute. If you don't do it, you're not running any risks. But the more you follow that kind of protocol, the more likely you're gonna have a smooth operation of business. And we'll go on that last point, defocus, talked about that. You have the ability to call people for being out of order. Do it very politely, but if you have matters on the agenda, they're busy people, there's people sitting in the room that have to get to their item, and would prefer people to not be voicing a whole bunch of discussion on things that have nothing to do with what's before them. So if there's a motion that's been made and pending, then that's the only thing that should be discussed at the time. There's ways in which somebody can make a motion to rescind that, and somebody else is interested and you want to stop debate. There's all different procedural things people can do, but there's a proper place for it, and the chairman's job is to try to keep that in place. Yes.
One quick question.
Mm-hmm.
This happened in this room not very long ago. There was a meeting of a commission, and there was a discussion going on among the commission members. Another member of the commission, sitting right there, confronted someone in the audience about something that was completely irrelevant about what was going on at the time, and what was being discussed.
Mm-hmm.
The chair completely ignored it.
Mm-hmm.
What should have been done in that case?
Well, you see, it's perfect timing. I bumped to another slide, and it's I got a bullet point. Any speaker can be stopped whose speech. The heading on this whole thing is freedom of speech. It's not absolute. And when the whole purpose of this parliamentary procedure stuff is to allow deliberative bodies to be able to move business. And if it was a free-for-all, you're not gonna get anything done. So one of the restrictions that's perfectly reasonable is when speech at a deliberative body becomes irrelevant. The chairman can call that out of order. And certainly you don't wanna have personal attacks, you don't have dialogue with members of, I mean, again, there could be audience of the citizens. I've been in meetings where everybody's having almost like a workshop discussion, and it made sense in that particular context. But generally speaking, a member of the commission shouldn't be engaging a member of the public, especially in some kind of a heated and personal way. And the way it should be handled is the chairman should have ruled the person out of order, and then return to the business before the commission.
Okay.
And, you know, next one, personal remarks in the debate are always out of order. You deal with the business, and, you know, things are perfect, people have, you know, their opinions, et cetera, but they can always be called out of order when a debate is not dealing with the business before the commission, but the people that are involved. The amount of time, you can set the amount of time for speakers, and then have an opportunity, we'll talk a little bit about that. I mean, in the traditional Robert's rules, which again is designed for larger groups, there's a two-time rule. You're allowed to speak, and then after everybody gets a chance to speak, you're allowed to speak a second time. Smaller groups, that's not a hard and fast rule. You have something and people can go back and forth and discuss it a lot, but there becomes a point in time where a question should be called. You can beat something to death if everybody's saying the same thing over and over again. So the chairman has the ability to try to avoid repetition. And that's another thing, that this is different than just operating your commission, but also operating to the extent you have public hearings. You know, if you do have one of those ones where you have 500 people in the room, you can suggest to members of the public, you know, we really like to avoid repetition. And if you have, you know, if people are supporting what somebody else has said, you don't have to say it all over again, and do things like that. I'm getting off topic a little in terms of pure parliamentary procedure, but in a public hearing like that, you can say all speakers should have 2 minutes to speak. But parties to the matter, if you have somebody who intervenes and they're a full party to the matter, and the applicant has come up and spent 45 minutes putting an expert on, presenting all this information, and then you turn around and you've got a neighbor who's hired an expert, you say, you got 2 minutes. That doesn't work. I mean, there has to be a fundamentally fair process. So in general, you can limit the amount of time people speak. There are some exceptions.
Ken,
Yes.
question. You're in the middle of discussing something, a motion's been made and seconded, and the discussion is ongoing. Actually, how does a chair do it if you've got somebody that stands up and actually is talking about that particular motion, but is being repetition, is it going on and on and on, you don't want to be rude, how exactly, what do you say? Does everybody have a time limit at that point, or you just try to stop them, or?
Well, if a member is being repetitious and going on, the chair can rule that as being out of order. And the way, you know, usually with small boards, you're not banging a gavel and say, out of order, out of order. Usually it's a nice, polite, we appreciate it, we understand what you said. I think everybody on the board understands, you know, your position on that. Is there any other, I think we should move on. Is there anybody else have anything?
I like the idea of getting Jane and Nancy Gavels, big ones.
Oh, no.
I can see you pounding the table.
We had one chairman of the Board of Ed that used to pound that table, oh, it drove us nuts. Anyway.
But, you know, I've seen a commission, I mean, they could not agree what time of day it was or what color the sky was. And I literally were arguing what time the meeting the meeting minutes should say that the meeting opened. And they started debate about whether it was 6:01 or 6:03. I mean, that's just how much they dislike them. And when you happen to have a dysfunctional board like that, you need a chairman who's going to be stronger in that case to prevent that shenanigans from happening and moving business. When you have a completely congenial body, things can be more informal. And that's something that, you know, and that can change from meeting to meeting. You've got something really controversial that's there, you might need to be a little more formal than you might be when you're just sitting around and the only thing on the agenda is some broad policy discussions that you have to talk about.
The last point on that slide, Ken, which says all comments should be directed to the chair, should be, but necessarily don't need to be. I mean, they could address somebody else on the commissioner board. Made the comment, and now it's rebuttal, I would imagine, but it's all supposed to flow through kind of the chairman. The
It should, I mean, that's the way, the one exception, and that, again, and that's good order because what can happen is what was mentioned before. You get somebody who, you know, maybe they didn't get along on the ball field 30 years ago, and they want to start attacking each other. When everything comes through the chair, you reduce that from happening. So it's just a good practice to have. There is one exception, and again, it's a land use kind of an exception, which is there is some cases that say a party has a right of direct cross-examination of witnesses. So commissions like Planning and Zoning and Wetlands Commission, it's a good idea to have questions come through the chair, but if somebody demands and say, you know, with all due respect, you know, Madam Chairman, I need to cross-examine that expert witness directly. There's some case law that says you have a right to do that, but it's only if they demand it. But otherwise, you can request that everything comes through the chair. This is some stuff that would put you to sleep. There's a couple slides on different kinds of Robert's rules, Mason's rules, Andrews rules, even, you know, what the physicians use and what they use in Canada. So I think we will bump past that. We already mentioned that the Robert's rules, it's in the 11th edition. The different editions, if you have an older edition, the chances of it being, you know, having a bit substantive change in it from what you had in an old edition that would affect you doing business for a Stafford Commission is extraordinarily unlikely. But if you want the most current one, it's in the 11th edition. And some of this is a little bit repetitious in that a lot of what the Freedom of Information requires comes out of Robert's Rules in the sense of adding something to an agenda. You need two-thirds vote. That comes out of Robert's Rules. The bylaws determine quorum. Sometimes the statute determines quorum. Sometimes you need a particular number of people. So, but typically it's just a majority of the total body. But you have to look at your own bylaws and or the statutes. If you have no quorum, then you really, what happens is the chairman would announce that there's no quorum and that the meeting, really hasn't been open, is recessed or adjourned really doesn't matter in that context because the meeting hasn't really started. Now, if quorum is lost, if you only have the bare quorum, and one of the members gets a phone call that their wife had just gotten in a car accident, and you've got to run out of the room, and you've lost quorum, the meeting's over. It's got to be declared to have been recessed or adjourned.
Could you seat another alternate?
Sure.
Okay.
Oh, absolutely. And that's what, one analogy while you touch on that, alternates are really, I think one way to look at it is like a jury. When you don't know, when you're an alternate on a jury panel, you're listening to all that evidence, you're going through the entire trial, and it isn't until the moment in which you're going to be sent in the jury room that you know who's actually going to be the acting jurors. Somebody might have got sick. Somebody might have been discovered that they've been talking to one of the witnesses and they get thrown out by the judge. So the same thing is true with a deliberative body where you're an alternate, because it could happen that the guy gets that phone call a minute before it was about to go to deliberation, that alternate gets seated. Once it goes to a decision, then the alternates who could participate, asking questions, can, as if they're a full member, because again, they might be the one that's actually making the decision, just like that juror might be deciding whether somebody is found guilty of murder or not. So they could be the one that's just as important as anyone else at the table when the vote's had. But once it's going to go to deliberation, the alternates should not participate in the discussion at all. Now I know that in some bodies that they do that, and I've not, there's some land use cases that are subject to reversal for that. I think that there are other kinds of agencies that might not be the case, but you gotta be careful.
Ken, what about the situation where a regular member is late, and then they indicate
Thank you.
an alternate is therefore standing in for him or her, and then the person comes in? What happens in that situation?
I think most commissions would then, well, two things. If that person is late and has missed part of a presentation on a matter, then that regular member shouldn't be seated, because there's no way that member can get themselves familiarized in what they missed. Now, members can familiarize themselves if the matter ultimately was postponed for decision to the next meeting, that member who wasn't there for the first part of the presentation could listen to the tapes, become familiarized, and then get seated at the next meeting. Now, if we're talking about a situation in which they're not in the middle of a presentation, it's just a regular meeting, and an alternate is seated, most commissions would seat the acting member in place of the alternate that's been seated. I don't think there's a requirement one way or the other. So if it's the practice of the commission that once if someone doesn't make the meeting and the alternate's been seated, I'm not aware of any law that would say it'd be inappropriate to keep it that way. But I can say the practice is that the regular member gets seated at that point in time when they arrive.
But that's the discretion of the chairman?
Yes.
Okay.
But again, I think that in the event that there's a presentation that's gone on, that the chairman shouldn't seat that person. I mean, you could seat that person for the next matter that comes up on the agenda, but not the one that the person has missed part of it.
I have a procedure question, Kim. On a public hearing, once you close the public hearing and then you bring it up under the agenda for a decision, and we have discussion, are the alternates who are not seated as a full member allowed to be part of the discussion?
Well, normally the only discussion after the close of the public hearing, I mean, if the discussion
I mean, if the motion is made and seconded and discussion,
if
are
the
they
motion
allowed?
is made and seconded on the application,
Uh-huh,
then no, they cannot participate.
they have
and-
been,
and-
so that's a no-no.
But there's a case that it was an open question, and people were, it's quite common that it happens. There was a case that's come out that said, no, that's not appropriate, that once it gets to the point, because it's almost as though you are a third party, you're like the public trying to influence the actual decision makers and how they're gonna decide. So once it gets to the point where the people have been seated who are gonna, and the question is on the floor. Now, if somebody is asking, all right, should we do a site visit? Do we think information? Right, that's different. You haven't yet put the question to, the substantive question to the body. So I think at that point, alternates participation in, whether things should be postponed, whether sidewalks, things like that, they can. But once the rubber hits the road and it's time to decide the matter that's before the body, then people who are not seated should participate in the discussion.
Okay, again, this is just for clarification. This is on any motion. Motion's been made and seconded, and you're asking for discussion. At that point, the alternates can or cannot.
Should not. But
They
again,
should not.
it should not. But that's come out of some land use cases where you got, I think that when you're dealing with a board of finance, which is a policy board, you don't get a lot of appeals out of, discussions about whether or not there should be a budget transfer. So I think a lot of boards of finance might be less formal that way, and alternates participate in the discussion. So much of this is common sense. But when you're dealing with a situation where you have a controversial application, where somebody, you've got people who might take an appeal, then that's where you have to be a little more rigid in how you follow the process. But from a technical standpoint, coming out of those land use cases, again, not like something like a board of finance or a council or something like that, there's advice that you do not have an alternate.
Because that's always allowed the alternates to
Right,
discuss.
and again, I think in a board of finance, I think is a different,
Okay.
slightly different, kettle of fish. And I
Thank
think having hearing perspectives from alternates, and then as long as it's, made clear who's seated at the point in time where there's votes, which is an important thing to do, and that's something the chairman can do very easily. Some commissions will have name tags out in front of people so you know who's an alternate, who's a regular member, but then on any given matter, the chairman can say on this particular matter that such and such are seated, because maybe one of them is, recuse themselves because they have, again, the Little League example, they've been the one that came up with the idea to have the new field, so they're gonna recuse themselves, because of that, direct interest in the matter. Then the chairman would announce that, Commissioner Smith is gonna be seated for Commissioner Jones. All right, your folks know standard order of business, that's no, and the kinds of orders, now, the stuff I'm going to, go through right now could make your eyes bleed. I mean, there is some really technical, Robert's Rules of Order things, that after I tell you all that, I'm gonna say what my spoiler alert was earlier on, which is with smaller bodies, it's more it's more informal. But you can use these as a tool, especially if you're dealing with a commission that is more challenged in the way that they do business, so that you do that. Now, the main governing documents, the things that you have to consider, some of them are mandatory. You cannot do something that violates the Constitution, both federal, state law. If you had a charter, you have to follow the charter. Now, bylaws down on this list, bylaws, special rules of order, parliamentary authority, standing rules, policies, and procedures. Those rules can be suspended by a two-thirds vote. And so if you do have a general way you do business by way of a bylaw, you could suspend the bylaw, but that's one in which people should know in advance, and it should be a two-thirds vote. So if you're going to change the way the procedures should go, that's not something, as you say, done on a whim, and it doesn't get suspended on the fly. If it's something that you expect that a meeting is going to take place, and you think that standard bylaw shouldn't apply, then people should be on notice that somebody's going to be proposing that bylaw be suspended. All right, the main motions, and that's the motion of the substantive issue that's before the body. The thing that they're ultimately, again, when the rubber hits the road, that's what they're going to be deciding. That motion should be made and it should be seconded. There's a slide we're going to come up to that says, Robert's rule says in very small organizations under 12, you don't even need a second. That's a bad idea. Motion should be made and should be seconded for boards of your size. You need a majority of those voting to pass. There's some statutory requirements, and sometimes you need more. If you're on a zoning board of appeals, there's a particular number of people you have to get, usually a supermajority, in order to get a variance. So this is under Robert's rules as opposed to what might be in statute or your own bylaws. But the maker of the motion has the right to speak. The chair has the right to call somebody out of order. And you know, long motions can be in writing. I mean, I see this sometimes if there's a big resolution and somebody said something and other members of the commission, you can ask that, you know, for a point of privilege to understand exactly what's happening. If you're a member sitting here and you couldn't hear the person at the end of the table, you have a right to ask the chairman, you know, without a second, an opportunity and privilege to know what the motion said. And that's why sometimes, you know, chair can ask, write the whole thing out so we can look at it. I think that's an exception, but you could do that. You can, you know, require somebody to speak up, and you could restate it to try to help persons, and we'll cover a little bit more about that. The 6 steps of a motion: it's made, it's seconded. The chair should restate it and ask for discussion. So the chair says what the motion is on the floor, ask for discussion, debate. Now, these are substantive motions. There are some kinds of motions that aren't debatable. The standard substantive motion, debate. Then the chair again repeats the motion and calls for the vote and declares the result of the vote. That's the ordinary 6-part process that we recommend. Again, there's some instances where commissions are a little less formal than that, but that's a good practice. The person, when you're dealing with debate, the person who makes the motion technically is often to speak first. It should be recognized by the chair. That's a good formal practice. Again, smaller groups, if you know, that can sometimes not be required if people are getting along. But to follow Robert's rules, that's the way. I told you about the second speak twice rule earlier, and you can call out of order the remarks that are unrelated to what's on the floor, and certainly like personal attacks, call them out of order, keep people on the straight and narrow. Debate can be limited, so there's 4 other classes of motions below the primary motions. There's the subsidiary motion, right, which is one that's directly related to the motion to amend, for example. There's privilege motions. Those relate to the welfare of the group. A privilege motion where someone states, a kind of a point of order question, or raises a privilege that they're a member and they can't hear what's going on at the other end of the table. Where the room is so boisterous, people are just talking amongst themselves and yelling, and I'm sitting down here and I can't hear anything. That's a subsidiary motion to request the opportunity as a member of the board to be able to hear what's going on. There are incidental motions, sorry, I lost the back, that talk about, and then restorative motions that are procedural, but they occur later in the process. So a motion that relates to what's on the floor, a subsidiary motion, there's a motion to postpone. Technically speaking, people use table all the time, and I don't think it's the case in Connecticut that would ever reverse anybody for using the term. Technically, the motion is a motion to postpone. A table motion is a motion that in the course of the meeting, if you want to take something out of order, debate's going on, but maybe there's someone here, maybe you got the town attorney who's costing too much money for the town, you want to have that matter go on ahead of another, you can table a matter that would otherwise be first in the agenda and make it third. If you're at the end of a discussion, you don't think the commission should do anything, or the body should do anything on it until a meeting in the future, or maybe ever, it's a motion to postpone, not a motion to table, but that's kind of a technical term. So a motion to postpone indefinitely or to a time certain is debatable. You can use a motion to postpone indefinitely basically to try to kill something, but either of those things are debatable. If you make a motion to amend somebody else's motion, that's also debatable. And if you want to send something to a committee or a small group, I think that's unusual probably for the commissions that you're on, but every now and then you have a commission that will have a subgroup, and you want to refer the question before the overall body decides it, that's also a debatable motion. Now, if someone wants to reduce number of speakers, length of speeches, that's something that's is not debatable, and it's amendable. So if somebody makes I make a motion that we cut debate to 3 minutes a member. Somebody can make a motion to amend that and say, oh, let's make it 5. All right, but the actual whether or not you're going to do it is not a debatable motion. A motion to move the previous question. You want to move the question and get it decided. All right, it's not debatable, but it requires 2/3 of the vote. Now, often commissions do, let's call the question. I move to call the question, everybody agree, and they don't stick to the formality of having 2/3. But if you're going to, somebody else wants to keep talking, and somebody else wants to say we've had enough, technically there should be a 2/3 vote of the body to cut off debate, and that motion to do that is not debatable. Now, a motion to lay on the table or a motion to table is also a non-debatable motion, and technically that's one in which you're basically changing the order of which it's considered during the course of that meeting, not one to postpone it to another meeting. But if everybody is accustomed to using the word, I'll make a motion to table it to the next meeting. Again, no one's gonna take an appeal and reverse you on that point. But if you wanted to follow Robert's rules, you'd call it a motion to postpone. If there are going to be, frankly, motions themselves should be precise. So the chairman, if it seems confusing and people don't understand, the chairman should state it and perhaps get the movement to make it more clear. But same thing, if there's going to be a motion to amend it, it's got to be germane to the question. If somebody's trying to make a motion to amend and it's completely unrelated to the substantive motion before the body, it's out of order. It should be declared to be out of order by the chairman, and then you move on. But if motion to amend is debatable. So that gets debated, and then once it's decided whether the motion is amended or not, then the overall motion as amended, if it was amended, is the one that gets debated. Privilege motions, emergency in nature because they relate to the operation of the business of the organization. So I'll jump to the second one because I've already commented it, but a motion to raise a question of privilege or point of order is where a member can't hear, someone has misstated something that they've said, they can, it's a point of order. That's not what I said, so if something was misstated, I want to make sure the record is clear. You don't have to get a second, and it is, in terms of calling for the orders, that is following, the first button there is following the agenda. You should be following the items on the agenda. If you're going to change the order, it would usually be by way of a motion to table, and that would require a vote of 2/3 to do that. Now, if someone on the commission calls for orders because you started to talk about things that are out of order, and ask for that, and you don't need a second, and Once it's called and somebody is not following the order and somebody calls that, it should go back to the order unless 2/3 of the vote. So that the chairman should, in that instance, if somebody correctly has pointed out, you moved on to item 3, and item 2 is what's on the agenda. The chairman, after the person, without having a second, says, your point of order, we're gonna call for the orders, you go back to the agenda, or the chairman could say, I'd entertain a motion that we table that, or we take these matters out of order, and we move item 4 to number 3, or number 3 to number 2, 2/3 of the vote agree, then it gets changed.
Okay.
Yes?
On a previous slide, about calling the question, it was, I remember, it was silent on whether you need a second or not.
On which one? On
Calling the
amendment?
question.
Calling the question? No, it does not. Calling, which one is that? Referral.
No, I think it was a motion to move the previous
Motion
question.
Cuts off debate, 2/3 needed, not debatable nor amendable. And I've got, you know what, got little cheat sheets I'm gonna hand out too, and I wanna make sure, to call the question, yeah, I know I was wrong, a second is needed, and to end debate, it's not debatable, you need 2/3, so yes, a second is needed. And I'll give you the cheat sheet that I just needed, because I don't have as much as I'm trying to teach this stuff, I'll admit that all of the entirety of the Robert's Rules I don't have committed to memory. This is something that you might find helpful, that will list I'll give you actually 2 documents. This is the Robert's Rules cheat sheet, and what it does is it shows you the different kinds of motions, whether or not a motion needs a second, whether it's debatable, whether it's amendable, and what kind of vote is needed, whether it's a majority. In some instances, it's just the chair decides. If somebody raises a point of privilege about noise in the room, or I can't hear, the chairman rules on that. That's not an actual motion that needs to be voted on by the body. So I'm glad you asked that.
Question. If a motion has been made and seconded, and it's discussed, and during the discussion, they find out that the first motion, the motion that was made, was incorrect, it really should be stating something else. Exactly, how do you get back to getting the original motion?
Well, one way would be a motion to amend. Somebody can make a motion to amend that.
And that's it, do you
if the
have to
person-
vote on the first motion to amend?
Yeah, a motion's made, and then somebody realizes that it was stated improperly. In the course of this debate, the person who makes the motion can ask for the privilege of amending their own motion. Or somebody else in the body could say, I want to make an amendment to that motion, so I want the motion to now read. It has to be germane to the motion, and certainly if the motion was misstated in some way and you think it should be stated differently, it would be germane. And then the motion to amend would be voted on, and then once it's amended, then you don't ever vote on the first motion, because the motion's been
Thank you.
amended, and then that's the only motion that goes forward. If the motion to amend fails, then you go back, and that motion, poorly or not, is what's going to be decided on. Maybe it fails because everybody thinks it's poorly drafted, or maybe it passes and just is a different point of view of whether or not it was well stated. All right, other privileged motions, motion to recess. Recess is to just take a break in the meeting as opposed to ending the meeting altogether. So, we talked earlier about somebody had to run because, their wife, had gotten in a car accident. It was pretty clear that it was something maybe less of an emergency, but somebody had to run out of the room and take an absolute essential phone call, and you lose quorum. You could announce a recess with the expectation that you're gonna call the meeting back to order in 10 minutes or 15 minutes, and then you call it back to order. If it's one where it's pretty clear you're gonna lose your quorum for the night, then you adjourn it. But if somebody makes a motion to recess, that motion is subject to being amended, but there's no debate, and a simple majority does it. Same thing, motion to adjourn, you need a second, no debate, no amendment. I mean, it's just a one, you're gonna adjourn or you're not. If you're gonna recess, it could be for 10 minutes, it could be 15 minutes, it could be, so that's why it's amendable. Motion to adjourn, it's yea or nay. No debate, and amendment allowed. One thing I see some commissions do is they take a motion's made to adjourn, somebody seconds it and everybody walks out the room. Technically, that's a motion like any other motion. Theoretically,
You need a
people
vote.
don't, well, everyone wants to go home. There are times where somebody might not want the meeting adjourned, so you should call for a vote on a motion to adjourn, just like anything else. There's also a motion to fix the time to adjourn, and that's actually, there have been some land use commissions where the damn meeting's gone at 1 in the morning. And the better practice is usually not, you don't have to go through the formality. At that point in time, somebody's gonna say, I think we should, adjourn the meeting. But somebody could, when they come to the meeting and they know something's gonna be long, and they know there's some, event in town that's gonna start at 9 o'clock. Start in the meeting, they can make a motion to fix the time that the meeting will adjourn. And that will need a second, there's no debate. It can be amended again, because somebody will say, okay, let's not say 9, let's say 9:30. But this is a motion that it does get acted on. Again, hyper technicality here, it's of all the subsidiary motions we're talking about, that's one that can be reconsidered. Normally, most matters, if you're going to reconsider something that you've already decided, one rule, I don't think it's touched in the slideshow, is usually the person in the majority, the prevailing side, should make the motion to reconsider if there's going to be a reversal or a possible reversal of the decision that was made. But there are some other ways to quash something the body has made in this. So a point of order is something that you think the chairman is not doing anything, is doing something inappropriately, or you're asking for something. There's no second, no debate, or an amendment. And if it's decided on by the chairman, and we'll touch on it in a minute, there is a right of an appeal of, actually it's the next one, that was the next slide. You can appeal the chair's decision. So if a point of order is made, the chairman makes a ruling on it, somebody can make an appeal of the chair's ruling on that. It has to be seconded, and the chairman gets to speak on it, and it can be debated. And there is possibility of objection to the consideration of a question. Again, some of these motions are things that are not likely going to happen in front of your local commissions, but somebody puts something on, tries to get something on the agenda, and somebody thinks the commission shouldn't ever entertain that. It's a terrible idea, and the commission, it shouldn't even come up for business. A objection to consideration of the question can be made. No amendment is allowed. There is no debate, but it needs 2/3 of a vote. And then finally, motion to divide a question, and that's something where usually if there's a question, a motion that's complex, and each motion has to stand on its own, or it's considered out of order. So if you try to divide something that simply doesn't make any sense, the chairman can make sure the question makes sense and not allow it to be divided. But it is an ability without a debate, and if it's not called out of order for being unable to stand on its own, then by majority vote, a motion can be divided into 2 parts. Or multiple, actually, it doesn't even have to be just 2. Motion to close nominations or close polls, it's amendable. You need 2/3 vote. Very commonly, I think, though, nominations are called, and there's often unanimity, and you're not going to worry about doing 2/3 vote. When you ask for nominations from a couple of times, and somebody says, I'd like to close nominations, and the tie. I mean, if it didn't seem like everybody was in agreement, you could poll and make sure you had 2/3 before nominations are closed. Motion to suspend the rules. You need a second, along with a 2/3 majority. And it cannot be debated, and it can't be amended. Now, that's a type of situation would be, maybe you have a rule that says how long speakers can speak, and somebody thinks we should change that for the purposes of a meeting. It can be amended that way. Division of the assembly, this again, that could be something that could happen at a town meeting where you have, a big room of people, and you want to find, it's not clear when somebody says A, yay, and nay, how the decisions come down. Somebody can require a standing vote or a hand vote or something so that it becomes clear who's who. Doesn't need a second, and there's no debate and no amendment.
Where is it?
Good stuff.
I think it might have been Peter's.
No, it's James.
Now, there's restorative motions, which are motions after something's been decided, you wanna get it back before the body again. One, I'm calling it a restorative motion, but something that's been tabled, then you can ask to have it brought back before the body. It's not debatable and it's not amendable. A motion to rescind, which you don't see very often, but if a vote is made, there's supposed to be advance written notice, so you had a decision that's been made. And let me tell you, there's some real, I would suggest you don't do this if you're a land use commission and there's a decision that's been published, because rights are vested, people are gonna take appeals or not. But under Robert's rules, there is an ability, if somebody wants to nullify a decision that was previously made, if there's advance written notice, it's by majority vote. Without advance written notice, you need 2/3 of those present and voting. It's debatable and it's amendable. So you can try to persuade the people that just made a decision to change their mind, and let's do it all over again by way of a motion to rescind, which is going to need 2/3 majority to do it.
That's basically a second chance.
Yeah, that is. But in an instance where you have that application, hotly contested application, decision is made, it's getting published, somebody has a right of appeal, and somebody wants in the next meeting to, let's decide it all over again, there's a lot of procedural problems with that. So I would certainly not recommend it in that context. I think that there's other situations where that kind of motion might make sense. Motion to amend something previously adopted, and it's just the same as what I just said. Motion to reconsider. It's a debatable if original motion, but may not be amended. And if it's on the same day, it's by a majority vote, and the person is supposed to be on the prevailing side. If it's on another day, it's going to be by a two-thirds vote on the motion to reconsider. All right, now this is the precedential order of motions, and anything above it is the most important is the top, believe it or not, which is the motion to fix the time to adjourn, and adjournment, and then recess, questions and privileges, calls of order of the day, lay on the table, and previous question. Those are, the order of precedence of a motion, with the motion to adjourn being at the top. Continuing down, motions to limit and extend debate, postpone to a date certain, commit or refer to a committee, a secondary amendment to amend an amendment, a primary amendment to the motion, to postpone indefinitely, which is to kill it, and finally, the main motion is at the bottom. So that's the floor is that motion, and all of the other kinds of motions are actually take precedent, which makes sense, because finally, at the end, that's when you're going to make a motion, you're going to make a decision on the main motion, but you got to get through all of the other ones before you get there. Now, this is the slide that says after everything I just made your eyes bleed over, you're not required to follow these. There isn't any case law in Connecticut that says that Robert's Rules of Order is binding. You can adopt your own rules that say so, and even those that we talked about, if there were your own rules, you can suspend them. So it's not like a specific statute. But there's even a principle that says that members are not required to obtain the floor, so they can just make motions. I think that's true with a lot of bodies. Madam Chairman, I make a motion, as opposed to a more formal, Chairman, may I have the floor? And you have to be recognized before you make a motion. That's how it would work with a larger deliberative body. That's when you watch Congress, if you spend a lot of time watching C-SPAN, which I don't think many of us do. You see that level of formality. With a smaller group, you're not going to have to do that. In some instances, the chairman might have to take control. If the commission is out of control and they're all talking at once, then the chairman might demand that I'm going to have you recognized before you make the motion. There's certain prerogatives that come with chairmanship, and you need to use that depending on your commission. But it even says that motions need not be seconded, and I throw in, we certainly recommend them. And so it would not be illegal if a motion is made and then the body just simply votes and the majority says that should hold up. But I think the typical protocol, when people make motions and make seconds, is a good way to do business, especially because sometimes somebody makes a motion that nobody else at the table would have any interest in voting for. Why waste your time having to vote on that if the person didn't even get a second? So that's that's where a second has some value. So, although I told you what Robert's rules say about that, with smaller meetings, that motions can be reconsidered, and regardless of when the motion was made, although I just gave you the caveat, if you're dealing with like a land use decision in which there's gonna be publication, and people have rights of appeal, you shouldn't be undoing that, at the next meeting. But if it's other, you're dealing with it, maybe a Board of Finance decision, and there's a decision to allow for a transfer, and people have second thoughts about it, and it hadn't happened yet, the next meeting, somebody could make a motion to reconsider what the body did the meeting before. There's no specific limit in the number of members can speak, but, and suppose the motions to close are limited, are not entertained. I don't agree with that, it's on the slide, but I don't agree with that. There comes a point in time in which you make a motion, often called to call the question, and I can call it to end debate. But discussion's gone back and forth, so he says, I move to call the question. I think it's a perfectly appropriate motion to make with small groups. And presiding, said very earlier, the presiding officer does have the ability to participate in the discussion and to make motions and to vote. Sometimes it's the protocol of chairman not to go on the record to vote when there's, other than to break a tie. There's no rule one way or the other that they have to. In the spot where it's very important is on zoning board of appeals, because, for example, because they have this requirement for 2 votes. If the chairman didn't vote, then an applicant for a variance would have a really hard time. All right, and the other, again, a lot of this goes to the chairman, but other members of the commission can support the chairman. There should be one item of business at a time. The motion has been made, all right, fine, the motion has been made, it's seconded, that's what you're discussing. Well, then somebody makes a point of privilege. You gotta deal with that issue first. If somebody wants to adjourn the meeting, you gotta deal with that issue first. You're not gonna have discussions on the motion to adjourn the meeting at the same time you have a debate on whether or not to approve the application that's before the particular commission. So again, chairman's job to try to keep it clear on what is before the commission at that particular moment in time, and call people out of order if they're venturing off the reservation. One time per meeting, that's referring to a reconsideration. You should normally decide something once and be done with it, right? There's still the the motion reconsideration that we talked, but otherwise you shouldn't just have people going back after you've left an item and have somebody just start talking about it again when you've moved on to another agenda item. Talk a little bit of majority versus 2/3 vote. I've got the cheat sheet that you folks can take with you that give you the example of the instances in which you need 2/3 vote. Silence, and that's the silence and abstentions are often treated as, unless there's an affirmative requirement of a number of votes, are treated as going with the majority. So even when you say you abstain, if you say you're not qualified to vote because you have a conflict, I'm recusing myself because I have a conflict, or because I'm not familiar with the record, I missed three nights of public hearings, I'm not qualified to vote. That's different. But if you're sitting at the table and a motion's been made and you don't say anything, it's presumed that your silence is in agreement with the majority. And do your best to treat everybody equally and fairly. So with that, are there any questions of let me hand this stuff out, because you might see I'll leave extras around.
Right, I think our concern on the P and Z is when we have to do it 2/3 as opposed to the quorum, which is 3 votes. And
Question,
that is
Ken, on the silence piece.
Yep.
So, there's a board of commission sitting there, and they make a motion, second, and call for a vote, there's silence. In the record of minutes, is that person's silence registered as a yea or nay?
Usually if the person says out loud, I abstain, the minutes are going to say abstain. But what a person, in terms, you got much left.
Just, yeah, give me just the leave extras over there.
But what, it should be reflected, if somebody says abstain, it should be reflected that way in the minutes, right? Because it's possible someone, you should disclose if the reason if you're recusing yourself because of the reasons I just stated, an alternate should be seated in your place. So you shouldn't just sit there and say abstain, and then you find out later, why did you abstain? Well, I had a conflict. That's really not the way it ought to work. But if you do abstain, and you can't be arguing, I didn't like what they did. So you're walking around town saying I've abstained, and then you're walking around town saying I'm opposed to that idea. Well, you didn't participate in the vote, so you really should be treated as if you were.
If you've tabled or if you've moved the discussion to the next meeting, okay?
Yep.
And one of the board members was not there, we had an alternate seated. That board member comes in, obviously wasn't in on the discussion. If it's not really being discussed again, that's when you would abstain, because they wouldn't know anything about the motion, correct?
You expect them to do that, but what can also happen, again, less likely in the Board of Finance, more likely in the Land Use Board, we have the regular member who's reviewed the tapes. I couldn't make the meeting last month, and I know there was a big, long public hearing for an hour and a half, but I've read everything, I'm familiar with everything. That regular member should be seated, even though the alternate was the one that was present during the meeting. With the Board of Finance, if there was a presentation that somebody could get themselves familiarized, then presumably they wouldn't, they'd abstain, and you'd have the alternate make the decision on that particular matter.
Couldn't you seat the alternate that was in, like say it came up again, and the alternate was in the audience, could he sit while that's being discussed and the motion made? That gets put to rest, then the regular board members sit?
Yes, yeah, in the example, let's talk about the example where the regular member missed the hearing, but hasn't had an opportunity to look at the tapes.
Right.
That alternate is gonna get seated, but now the regular member has shown up, on the matter in which the alternate is gonna sit will be the matter in which the regular member wasn't present, but then the regular member can be reseated to consider the new matter.
Okay.
So it
All
doesn't,
right.
it's not for the whole meeting. You don't
But
have
does
to-
the regular member have that choice? If that regular member says, no, I'm gonna sit, he has the right to sit, doesn't he?
Yes. So,
The
in
chair
fact,
doesn't
in fact,
decide?
to be honest, a member who has an outright, absolute conflict of interest was the example who came up with the idea of the new ball field, that did the whole thing and decides, I'm gonna sit. The commission can't do anything about it.
I think you told me the rule was they can recuse themselves or a judge can recuse them, period.
That's it. Or the voters can recuse them for a more permanent period.
Ah, yes.
But that's, you can't have a vote, you can't say, I make a motion that Commissioner Smith not be seated because he has a conflict of interest. No, it's the commissioner's job is presumed to understand the law and do what the law calls for, and if he or she makes a misstep, is subject to having that decision reversed.
If you know Commissioner Smith does have an out-and-out conflict, has decided to sit, has decided to vote, what is the chair's responsibility? Are they to report it to, and to whom?
Nobody.
No.
The vote's been had and the vote's made, and that commissioner decided that commissioner should do. I mean, if what we're talking about is an ethics thing and you have an ethics board, or you've got somebody who, you see been paid off walking in the room, I mean, that's another thing, maybe there's a crime involved, and the person you're gonna contact is the police, but
Other
in
than that,
in
no.
terms of your belief that somebody shouldn't have sat on something because they have a conflict and it's a matter of ethics, there really is nothing you can do, the vote was had, and the person's a regular member, and they're entitled to vote. You'd hope you could do that, you have the ability, non-quorum, a member can talk to another member and say, I really think it'd be a bad idea for you to sit tonight on this matter in which you're proposing the thing that you created in the first place, and you can certainly suggest it, but that's something that ultimately the commissioner has the right to make their own decision of whether to sit. Any other questions? It's a long one, and this does a pretty good job. I think, again, this is designed as a more formal Robert's Rules of Order when you're dealing with deliberative or larger bodies, but understanding this, you know, when somebody does try to amend a motion, or somebody does try to reconsider something, or somebody tries to stop it, having a general idea of whether something's debatable or not can help things. You're not gonna waste 15 minutes. You can just declare as the chair, that's a non-debatable motion. What's your pleasure? It gets voted on, boom, you go on to the next piece. That's why the rules exist. So having an understanding of the more formal ones, understanding you have the ability as a body to be a little flexible when it doesn't make sense to be this rigid, you have that right. But when the time comes that you've gotta use it because it helps move business, that's what it's for. And you should do that. And I will check on the question you asked earlier, and report back if I can get an answer. I don't think that one before.
Ken, I wanna thank you on behalf of the town, I appreciate it, it was
All right.
excellent job.